The Honorable Judge Guy Reese presiding.
You may be seated. Good morning. Good morning.
Good morning, Judge.
Okay. First of all, I just want to state that I had received some information that I had said something about those that could attend and not attend. I did not make any such statement. I'll say that up front. I have zero problems with who's here and who's not here. That's certainly an individual decision as to whether you want to appear. Appearances, please.
Your Honor, Dominic Vitantonio on behalf of the state.
Kimberly Kendall-Crawl on behalf of Michael Amiott.
All right. Thank you. A couple of preliminary matters I think we need to take care of first. Defendants, at the conclusion of the case and verdict, filed a motion for a new trial. The court has had an opportunity to review it along with the memorandum contra that was filed on behalf of the city or state. Any further arguments with respect to the motion for a new trial?
Judge, I believe the motion is thoroughly briefed. I think we've met the threshold to be granted a hearing on the matter, but I'm not going to offer any additional arguments that would rest on the briefs.
On behalf of the state?
Your Honor, likewise, the state will rest on the brief in opposition, Your Honor.
I had written a number of pages here to read into the record with respect to whether or not this motion should be granted or denied. I think certainly the defendant is within his right to contend that a new trial is appropriate under Rule 33 of the criminal rules. However, after reviewing the motion and the memorandum, the court is not convinced that at this time that an order should be issued. But the basis was, number one, that the prosecutor fabricated and asserted certain things concerning a conversation that was not true. Arguments by the prosecutor concerning the jurors' desire, what they desire in their community. The instructions that the court provided. But after reviewing all of that, I feel that any errors that were made certainly were cured with the instructions provided to the jury, especially dealing with the arguments of counsel, because I emphasized repeatedly that those arguments were not evidence. Basically, the interpretations of what the attorneys felt the evidence was. And I don't believe at this time, while some of the remarks may have been inappropriate, I don't think that they reached the level to where prosecutorial misconduct would warrant the court granting a motion for a new trial. Certainly, I'm sure defendant will have an ample opportunity based upon the outcome of the case to appeal if that's his desire. The court did instruct the jurors appropriately, although there were a few hiccups during the course of instructions. Therefore, the court at this time will deny defendant's motion. The defendant also filed, first, the plaintiff filed a motion asking the court to take action concerning allied offenses and finding that the offenses in this case were not allied. Any further arguments on behalf of the state?
Your Honor, no, the state filed a brief laying out our perception of the allied offenses law, and we believe that the two offenses of assault on the one hand and violation of a civil right on the other hand are not allied offenses for all the reasons stated in the brief, and we'll rest on that, Your Honor.
Yeah, but in order to get to one, you had to do the other, correct?
Well, that's our argument. Our argument is that the stop was separate from the assault, so they're not allied. That's our position.
Noted. Counsel?
It's interesting that the state is making the argument that the stop is a separate offense than the assault, because Mr. Amiott was not charged with a violation of any crime for the stop. The interfering with civil rights lays out the facts supporting that charge in the charging document, which is the assault. It mirrors the exact same language. The jury instruction mirrored the exact same language. And so the state now asks this court to sentence Officer Amiott separately for conduct which he was not charged for, which he has not been afforded due process for, and which would be in violation of his constitutional rights. As set forth in our brief, as a matter of law, both counts are supported by the exact same facts. They were both committed at the same time, a single victim, and they are allied offenses as a matter of law under Steve v. Roth and under the statutory language. And so it's our position that this court can only go forward sentencing on one of those two counts.
Anything else?
Your Honor, just based on that, Your Honor, as the court knows, what you look at in allied offense analysis is the conduct, the animus for the conduct, and the effect of the conduct. We laid it out in our brief. We'll stand by that, but the court heard the evidence, the jury heard the evidence. The conclusion was the evidence supported those two convictions, and like I said, we'll rest on our legal position in the brief.
Thank you. For the purpose of sentencing, the court will merge the offenses for sentencing. Defense filed a motion to dismiss.
Before we move on, Judge, if I may, on that topic,
Yes.
can I inquire which of the counts the state wants to move forward on?
I don't know yet. I'll make the decision as we proceed. Motion to dismiss. You want to address that? You filed a motion to dismiss today.
Yes, we filed a motion to dismiss for undue delay and unnecessary delay in sentencing. The case law in Ohio is clear. We set forth that case law in our brief, that unreasonable and unnecessary delay divests this court of jurisdiction to sentence. Some of the cases we provided show that an 84-day delay in sentence, where the only reason given was overcrowding in jail, is an unreasonable and unnecessary delay divesting the court of jurisdiction. In this case, it's been discounting the period of time where defense represented unavailability. Even discounting that time, there's a 200-day delay. The total time is 241 days, but in discounting my unavailability on Fridays during finals season when I was teaching, that cannot be construed against the court with the state, but the other 200 days qualifies unnecessary delay based on the case law by the Ohio Supreme Court and all the districts who've interpreted the matter.
What's the harm?
It's not a harmless error analysis, Judge.
Well, I'm still asking what's the harm to your client?
Well, the harm is not a relevant question. It's a jurisdictional
It's relevant to me, I'm asking.
It's not relevant to the legal consideration.
Well, I'm asking.
The harm to the clients is that this has been going on for 6 years.
I
So
agree.
any ongoing delay continues to interfere with his life and the manners that pending criminal cases interfere with defendants' lives.
Okay. Counsel?
Your Honor, I think if there's anything that we can agree on, Your Honor, it's probably the proposition that in connection with the delay analysis between conviction and sentencing, all of the case law can be synthesized to say basically that the question is reasonableness. Is the time lag reasonable under the circumstances? And I think it is relevant. One of the inquiries into that reasonable analysis certainly is, how did it affect the defendant? If it did, I mean, you could envision a case where a defendant is sitting in jail for 30 days, 60 days, 90 days, 6 months. Sure, that it has a negative consequence to the defendant, and that weighs into the reasonableness analysis. Some of the case law, Your Honor, indicates that, there's a 3-year delay. Meanwhile, the guy's sitting in prison in Colorado and he's waiting to be sentenced in Ohio, and the court said, you should have went out there and got that guy and brought him back and had him sentenced. So we vacate the sentence. So there's a lot of considerations that you could consider in the reasonableness analysis. I don't know, I know the court that Your Honor, I know you're not from this court and you were brought in, and so I don't know what your schedule's like. I don't know why the case was continued, the 1 or the 2 times that it was. I don't know, but the question is, whatever those reasons are they reasonable?
Anything?
Yes, if I may, the state has again summarized that the case law holds that one of the considerations is the harm to the defendant. That is not one of the considerations. The case law is abundantly clear. I cited dozens of cases in my brief, but Ohio's 8th district, the controlling district here, is whether society will derive a benefit from enforcing the sentence, whether the defendant contributed to the delay through his own wrongful actions, and the length of the sentence relative to the length of the delay. Here, the maximum sentence is less than the length of the delay. And while the question is reasonableness of the delay and not harm to the defendant, Officer Amiott has been prohibited from working overtime during the pendency of this case, and so that has had a financial burden on him. He worked an average of 300 hours of overtime a year plus side jobs prior to this case, which he's been unable to do during the pendency of this case. So it's not to say that there's no harm here. The harm is ongoing.
No, but that OT is not something I think the court necessarily should be considering.
I would agree. I think the harmless error analysis in general is not something the court should be considering.
Okay. When I look at this case, I look at, number one, when were the charges filed? How soon after both the incidents involved? When did that occur? That's not a question.
Okay.
That's just out there. When did that occur? I look at when the prosecutor was assigned as a special prosecutor. I look at when I was assigned as a visiting judge. And I also look at the conflicts that have arisen, some caused by my schedule. Well, maybe a lot of them caused by my schedule. Some caused by the prosecutor's schedule. Some caused by your schedule. And when I put all of that together, I find that, when I initially tried to set sentencing in this case, there were conflicts that threw it up in the air, caused by primarily myself and the defense attorney, not necessarily the prosecutor. And yes, it's been quite a while, longer than I would appreciate, would want to occur. But I think given the overall situation that we found ourselves in, it's not unreasonable to have sentencing today based upon a conviction that occurred last year, significantly, a long time ago. I find that the officer has been working. Overtime is not a given. And based upon that, there's really been, while harm may not be the overriding thing, really, I think that the most overriding situation that has occurred with all of this maybe has been the public's perception of what's going on. And that's something also that the court has to consider. But your motion to dismiss is denied. Any other preliminary matters on behalf of the state?
No, Your Honor.
On behalf of defense?
No, Your Honor, understanding your reasoning and, it's a duty bound to raise all relevant issues. I think I also
Understood.
I think I also, to preserve the issue, have to object on the record to your ruling.
Understood. Understood, not a problem. You may proceed. The court did share a order of pre-sentence investigation report, and given the fact that and I always mispronounce your name, Mr. Amiott, I requested a pre-sentence investigation report that was conducted by the Cuyahoga County Common Pleas Court to ensure that there would be no conflict there. I've shared that with counsel, and at this time, on behalf of the state, you may proceed, counsel, anything at this time.
Your Honor, I have reviewed the pre-sentence report this morning, which was provided to me by the court. I don't see anything that jumps out at me as being inaccurate or anything that I'd want to comment on. Your Honor, I'll be brief, Your Honor. As the court well knows, the purposes, the overriding purposes, as the statute says, of misdemeanor sentencing is twofold. It's to protect the public, and it's to punish the offender. And the statutory language basically says the court could consider anything that it believes to be relevant. It says the court shall consider things like the effect on the victim, i.e. a victim impact statement. The need to change the offender's behavior, the need to rehabilitate the offender, and any restitution issues that might exist. That's all laid out in the statute. And then, of course, we all know that the court has discretion to come up with a sentence that, in its estimation, is the most effective way to implement these overriding purposes. The only thing, Your Honor, I would say that, obviously the court heard all the testimony. The defendant, Mr. Amiott, testified. You heard from the victim, Richard Hubbard. He testified. The court heard all the evidence, so I say that the court is in the best position, obviously, to fashion an appropriate sentence based on the statutory language and the purposes. The only thing I would like to do, Your Honor, is to allow Mr. Hubbard, which of course he has a constitutional right to do, to make a victim impact statement, and he'd like to do that. Please.
Mr. Hubbard, you may proceed if you would. Just state your name and then you may proceed.
My name is Richard Hubbard, and I appreciate the jury and the court for making the right decision. What Amiott did to me was wrong. He should have received the maximum sentences today. I'm still going through the suffering with the anxiety, driving, just the temperament, the trauma, and everything. This is a cause for this case. I'm ready to get it over it actually, but just coming back in here, just bring up everything, and just to see him over there, see all that, just coming back in this court, just it just brings up everything, we live in the moment. So I hope you get the maximum sentences today, Your Honor.
Anything else on behalf of the state?
No, Your Honor.
Counsel?
Thank you, Judge. I am going to make a few statements, but I'm going to reserve to do that after Officer Amiott makes some. Is it okay if can you stand at the podium?
You may.
To make some notes later.
morning.
Good morning.
Thank you to the court for allowing me a few minutes to speak. It's been a long road. I was 31 years old at the time of this incident. I'm 37 today. As I get older, I tend to put things in perspective more. We're all molded and shaped by our experiences in life and the outcomes of those experiences. This incident is no different for me, and I learned a lot as I look back. I know I've certainly changed in many ways, far from a perfect person. The one thing I've always done is look back and reflect on my mistakes and failures. It is very important for personal growth. History is a great teacher. The only problem is you can never change it. You can't rewrite it. You can only learn from it. It feels like we've been polarized to feel that people on both sides of this topic are either all good or all bad. But the truth is more nuanced than that. The procedure leading up to this moment has exposed me to what defendants are really up against once they're accused in this system. This case was investigated by numerous outside agencies. With the media attention the case got, it certainly should have been. After all, investigations are a search for the truth. I want the public to know what really happened to get us to this point. From day one, I cooperated fully with my own department investigation, Cuyahoga County Sheriff's Office Use of Force Investigation Team, and the FBI. I was repeatedly interviewed by numerous investigators in 2017. I never downplayed my actions. These investigations were reviewed by my local department, county sheriff's deputies, federal agents, local prosecutors, county prosecutors, and federal prosecutors. At the conclusion, I was never charged by the city, the state, or the federal government. 2 years after this incident, in 2019, the special prosecutor filed charges after negotiating a salary of $250 an hour. Pre-trial stretched on for another 3 years before trial. During the trial, I was disappointed that the jury didn't get to hear about the findings of those investigations or to hear from a single investigator. I was also disappointed about how known falsehoods were allowed to be presented like the truth. One of the most shocking examples was a prosecution witness called who testified that I was celebrating in the aftermath of this arrest. He testified that I was high-fiving, fist-bumping, and dapping it up with other officers. There was 5 police cars on East 228th Street that day, all with their dash cameras on and rolling. They all had overlapping fields of view. I can be seen in front of one of those cameras the entire time I was on scene until I was transported to the hospital. Nothing remotely close to what the witness described happened with me or any other officer on the scene. They knew this and put the witness on the stand anyway. This was a use of force encounter that divided a community. It is something I've replayed in my head for the better half of a decade. This is not something I've ever celebrated. I take full responsibility that there was a failure on my behalf to get Mr. Hubbard in custody quickly. The incident was prolonged when I was shot with a taser. During the deployment, I broke my hand, ruptured tendons, and injured my shoulder. When most people see a violent encounter like this, they usually ask, are officers allowed to punch people? And if so, under what circumstances are they allowed to do it? For me, it was important to attempt to educate the jury as I was educated as a police officer. I called every relevant instructor I had to the stand. Taser instructors I had, Department Use of Force instructors, captain in charge of the Use of Force Committee, my Police Academy Use of Force instructors, and traffic stop instructors. I hired a national use of force expert who reviewed everything. Each of them agreed that I acted within the scope of my training. Use of force is supposed to be judged from the perspective of a reasonable officer in light of their training and experience. Every officer testified that my response was consistent with the law, policy, and training. We also submitted handbooks, training documents, and videos supporting the testimony. Regardless of how I feel about the situation, I accept the jury's verdict. However, it's become clear that there's a disconnect between how officers are taught to react and how the public expects officers to react. I cannot change the outcome here, but I can make positive changes going forward. I have to figure out how to move forward and make sure I don't end up here again. As a community, we have to figure out how to come back together and make sure we don't end up here again as well. Our law enforcement training must keep officers safe and also be consistent with public policy. A lot of changes have been made since 2017. And if you can give me just another moment, I'm going to talk about a lot of the changes that I've made and the department's made. During the aftermath of this incident, the department started looking at alternative use of force training that does not rely on striking. Several officers were sent to become Gracie survival tactics instructors. These instructors now teach a revolutionary defensive tactics system based on Gracie Jiu-Jitsu. These tactics are more effective at subject control. Instead of pain compliance through strikes, kicks, tasers, etc., it utilizes mechanical control holds and body positioning. I think the leadership of my department would attest that I've championed these efforts. Early data from one department utilizing this program regularly shows a 48% decrease in officer injuries and a 53% decrease in suspect injuries based on employment of Brazilian Jiu-Jitsu in their patrol division. The department found that physical confrontations with suspects were 200% more likely to be injured by an officer that did not have the same training. They also reported a decrease in taser usage and workers' comp claims by $70,000 per year, which was significantly less than the cost of the program. I'm proud to share this is now part of our Euclid Police Department's annual defensive tactics training program. Previously, I had 4 hours of training every 3 years. Now the training is completed at least on an annual basis. I've personally taken at least almost 100 hours of training outside the police department and around the state pertaining to use of force and human relations since this incident. The Euclid City Council has provided funding to officers, giving them the option to seek additional training, additional use of force training on the officer's own time at a local Gracie Jiu-Jitsu school. The school is owned and operated by another local police officer. I've taken full advantage of this opportunity so far, and out of all the officers participating in the program, I've advanced the furthest and attained the most rank since this training program began. Euclid received some grant money through COVID. I worked with a group of officers to get some of that money to build a new use of force training room. We were given approximately $20,000 for materials to price, design, and build a new defensive tactics training area. I helped design the new room. I personally constructed a large 1,120 square foot training mat complete with wall mats and department logos. I put in every screw, nut, and bolt into the new training area myself. We've never had anything like it before. I worked with one of the defensive tactics instructors to create waivers so we can use the new training area on our own time, using department techniques to get the repetitions we need to not only be more effective on the streets, but to keep suspects and officers safer during these encounters. I want to end by saying I'm not an advocate for or against use of force. Everything I did on that day was based on my training and experience. From here on out, I'll be an advocate for subject control training department-wide going forward, so we can all be at our best when the time comes. I have a deep respect and love for the citizens and this community. I want to do my best to serve them. After all, it's what they deserve. Thank you.
Thank you. Counsel.
Thank you, Judge. I just have a few additional considerations. I'm just going to go over some of the statutory factors in misdemeanor sentencing in our application here, pursuant to 2922. First, this court shall consider the nature and the circumstances of the offense. I think one thing we learned over the course of this trial is that use of force cases differ than traditional assault type cases for a number of reasons, but in one way it's that officers are exercising authority that they're authorized to exercise, and the jury is determining whether that exercise was reasonable. And so this is not a situation where Officer Amiott went into the incident with the intent of breaking the law or violating public trust. But as things escalated and his judgment in the moment escalated, while we accept the jury's finding that his use of force was not reasonable, it's important to illustrate that it is not the worst kind of offense. This is not an offense that was entered into with the intention of violating the law. And as Officer Amiott explained, the consideration of the factors here have been analyzed with the media coverage of this case really worldwide for a period of years. And what we can see is that many minds, many qualified and educated and experienced minds on this topic differ. And for example, both state and defense experts were consulted and found force to be reasonable. And a neutral arbiter reinstated Officer Amiott to his job after reviewing the force. And that's not to undermine the jury's finding, but to highlight just how razor thin the line of judgment we expect officers to hold is, and how when every person looks at that judgment, they come out somewhere a little bit differently. And in all of these years, in all of our reflection, in all of the evidence presented to the jury, we've had a sufficient amount of time to reflect on that, but Officer Amiott conducted that entire analysis moment by moment. This is not the worst type of the offense. This court is to consider whether the circumstance of the offender or the offense indicate a history of persistent criminal activity. Here they do not. Officer Amiott has no criminal history, and beyond that, he, in the 6 years since, 5.5, 6 years since this occurrence, he's had no incident, even despite being under very strict scrutiny as time has continued. The victim's age, youth, or disability is not a relevant consideration here and falls in favor of the defendant. Whether he's likely to commit future crimes in general, not only have the past 5.5 years indicated that he is unlikely to commit future crimes, but his entire life history is zero criminal history leading up to this. He's a public servant, and while we can accept the conviction in this case, it doesn't separate Officer Amiott for the good that he has to offer his community. Another thing this court is to consider, can consider any factors. Proportionality is a factor. Proportionality in the sentence as compared to other sentences rendered by the same court in the same jurisdiction. Having consulted with other professionals who work in Euclid Municipal Court, other attorneys, other police officers, and Euclid Municipal Court's general stated policy, I can't find a single example of a time that an offender of any career or position has been sentenced to jail for any misdemeanor on a first-time offense in this jurisdiction in the last 10 years. So we would ask that the court consider proportionality in its sentence. We would further ask the court to take into consideration the amount of time that has gone by in this case and the fact that collateral consequences always exist for criminal defendants who are in the system during the pendency of their cases. The state brought up rehabilitation, and I think Officer Amiott highlighted some of that rehabilitation. And when he's using terms like defensive tactics, I want to articulate that what he's talking about is not more of the same, but moving away from what we saw from his own police academy trainer. If we remember during the trial, we saw a video of the police academy trainer saying, "Now drop an elbow, now throw a strike." That was the training of the time prior to this incident, and Officer Amiott has taken this opportunity to champion training which moves away from terms, concepts, and conduct like pain compliance, and uses subject control in place of striking, kicking, tasers, aspeton, and really reduces harm not only to citizens who have police encounters, but to officers, to the expense to the community. And so not only has he rehabilitated himself, but he's acknowledged that there is a difference between the way the community expects police to conduct themselves and the way police have been told to conduct themselves. And he's tried to remedy and close that gap so that the entire Department of Euclid can better serve its community. Lastly, during the pendency of this case, Officer Amiott has been exposed to a tremendous, and everyone involved here, exposed to a tremendous amount of media engagement, which has brought out both the best and the worst in public discourse. And even despite that, he's continued to serve his community in the best way he knows how, and he's continued to educate himself to prevent himself from being in the situation again. We would agree with the pre-sentence investigation report in this case. Officer Amiott presents in the lowest risk factors in every category. It's recommended non-residential community control sanctions are recommended at the lowest level of supervision, and we think that is an appropriate sentence for this court to impose.
Thank you. Officer Amiott, your counsel mentioned rehabilitation. What does that mean to you?
Well, rehabilitation is changing stand up, sorry. Well, rehabilitation would be changing behavior, in my mind, in order to not move away from different outcomes. So like in this case, for example, we got here for, I believe, punches in the duration of the fight. If there's a better way or faster way to do it, then the police department's looking into ways to do that. So a lot of that's being taken, for me, training at my own time, and the department's done it. That's rehabilitation to me is changing behavior.
You know, I'm listening to everything that was said by everyone, and particularly what you were saying. One of the things that I did not hear, you did not address Mr. Hubbard at all. And I'm not saying it's something that need to be done, but it's an observation that I made. And part of that, I try to observe and see what's going on and listen. And you can be seated. I'm going to talk a little bit here. I just wanted to ask that question. I didn't just sit here and let the trial pass me by. I observed the testimony from everyone. I listened. One of the things that stood out to me is that the initiation of this incident probably never should have occurred when you received that initial radio communication. That initiated this whole thing. And the other thing that sort of stood out to me was that in approaching the vehicle and asking Mr. Hubbard to get out of the vehicle, from my perspective, there was an inability for him to get out of that vehicle without making contact with you. Inability to get out of that vehicle. I appreciate the things that you said about mistakes and failures, the amount of investigation that's gone on, that took place as a result of that. And I appreciate all of that. You know, I personally spent over 30 years in the military. So I'm used to having orders, following orders, obeying orders, a regimented order of things. I'm accustomed to that. And I appreciate the necessity of police having the ability to, we need them. We need them to do their job appropriately. And when we deviate from that, then we have to do what we need to do to ensure that it doesn't occur in the future. And I appreciate what Euclid has done, the Euclid Police Department has done with respect to modifying how contact is made and how you get people under control. And police need to be able to control folk, no doubt about that. There must be control. But there's a limit to how that's done. And based upon the evidence that was presented in the testimony, and I did listen to your trainers, your prior instructors, I did listen to them. But I do believe in this case, I believe the jury got it right. I do. And the court must impose the sentence that the court feels is appropriate in a case like this. And I appreciate the information provided in the pre-sentence investigation. And generally, I'm the type of person that generally follows recommendations, generally speaking. I'm not here today to send a message to the world. I'm here today to evaluate what occurred here, and especially given the length of time that has expired since this incident and to today, take what I think is the appropriate action in imposing a sentence. How long did Mr. Hubbard spend in jail?
I think an hour or two.
An hour or two. Okay. Okay. Good. That's a good thing. Mr. Hubbard, let me say to you, it's been 7 years.
Yes.
The city of Euclid compensated you.
Yes.
If you need assistance, you need to go and get that assistance. But I'm not going to say you're not going to have instances of flashback or what have you, but you need to move on with your life also.
Oh, yeah, yes, for sure.
And not let this incident continue to hover over you. The city compensated you. Counsel, I appreciate your comments with respect to the things the court is required to take a look at in imposing a sentence. Based upon the evidence presented and the pre-sentence investigation, the court at this time will impose a sentence of 90 days, require you to pay a fine of $1,000, and will require you to pay the court costs. In addition, the court will suspend the sentence of 90 days, place you on non-reporting community control for a period of 1 year. If you violate during that 1 year, then the court will retain the ability to impose the sentence. Anything on behalf of the state?
No, Your Honor.
On behalf of Mr. Amiott?
Just what count is the state court electing to sentence?
What count? While Mr. Hubbard's rights were violated, and the officer, as an officer, he used his authority to do that. However, given the length of time involved here, the court will use the assault as opposed to the violation of civil rights. Not saying they weren't violated, but given the length of time, the court will use the assault charge. Anything else?
No, thank you, Your Honor.
That's all. Good luck to you, sir.
Thank you.
I'm still troubled by the fact that you did not address Mr. Hubbard.
I can address it.
I know that's all right, Your Honor.
No, it's not all right.
I don't need it.
You do need it.
Range.
You say you can't move on. I'm telling you, you need to move on. Not easy. Life is not easy. But as long as you let that handicap you, he has control. As long as it handicaps you, he has control. You make that decision, sir. Do you want him controlling, or this situation to control you?
No.
You need to think about that. That's all.
All rise. Court is now adjourned.
You all do what you want to do.